Good day, everyone. Welcome to Ready, Set, Go. This is a webinar series sponsored by HUD's Office of Special Needs Assistance Programs, which we also know as SNAPS. My name is Tony Gallo. I work at ICF International, and today I will be serving as moderator for this presentation. The Ready, Set, Go webinar series, and for those of you that don't know, SET is an acronym which stands for SNAPS E-Learning Tuesdays, is being held every Tuesday at 3:30 p.m. Eastern Time for the foreseeable future. The Ready, Set, Go webinar series provides valuable information and insights for continuums of care, HMIS administrators, grantees, project sponsors, and other stakeholders on a variety of topics focused on community planning and capacity building. So on behalf of SNAPS, I would like to thank you all for joining us today. Today's webinar is called General Program Requirements for ESG. We're lucky to have these national experts presenting today, including Michael Rowenhouse of the SNAPS office at HUD, Margaret McFadden of TDA, Janet Pershing of ICF International. In addition to these presenters, we're thankful to have two individuals who will be working as resource advisors, including Brett Gagnon of the SNAPS office and Fred Berman of the National Center on Family Homelessness. Presenter one, Margaret McFadden, is Vice President with Training and Development Associates. She has over 30 years of experience in program design and management with state and local government, not-for-profit organizations, and for-profit housing developers. And she serves on the SNAPS ESG Advisory Team and ESG Work Group. Michael Rowenhouse is the Director of Program Coordination and Analysis Division at the SNAPS office. He directs the Emergency Shelter Program, helps manage the HPRP program, and oversees policy on the homeless elements of the Consolidated Plan, HMIS, and the point-in-time and housing inventory counts. Presenter three is Janet Pershing, who's a project manager at ICF International, who provides technical assistance on a number of HUD programs, including ESG. Brett Gagnon, one of our resource advisors, is of the Special Needs Assistance Program office as well. She has been instrumental in providing assistance in the development of the regulations in support of the HEART Act. And finally, we have Fred Berman, who's a senior associate with the National Center on Family Homelessness, who has experience in the continuum of care world as well as HMIS. Next slide, please. Before we get started with the actual presentation, I just want to make a couple of logistical announcements. Today's webinar will last approximately 90 minutes, and it is being recorded. A link to the PowerPoint presentation is being sent to you via the chat function on your GoToWebinar toolbar, and the slides are posted on the Homelessness Resource Exchange website at www.hudhre.info. Many people have registered for this webinar, hundreds in fact, and because of the large size of the audience, all attendees will remain on mute for the duration of the broadcast. In addition, scattered throughout the presentation, we have inserted some poll questions or quizzes to help target our discussion. You'll be asked a question and directed on your screen to select your answer. We will then provide you with the results and the answers, and in some cases, discuss the implication of the answers. Next slide, please. For audio, please use the telephone and not your computer. If you have technical difficulty with the audio or video portions of the webcast, first please try to log off and then log in again. And then if you're having problems with audio or you're able to get into GoToWebinar but are having problems viewing the presentation, please request help through the questions function in your GoToWebinar toolbar. Next slide, please. All of your questions, your content questions, are very important to us. Unfortunately, because of the tremendous amount of content in this presentation, we won't have time to answer your questions live. However, if you do have questions, please use the question function in the GoToWebinar toolbar. There is a space where you can type your question, and the resource advisors, Mr. Berman and Ms. Gagnon, will answer those that they have time to get to during this presentation. In addition, many of the questions regarding the ESG program have been answered in previously conducted webinars and in other materials which will be posted on the HRE. Next slide, please. If you have a question that is not answered during the webinar by one of the resource advisors, please submit it afterward to the HUD Virtual Help Desk at http://hudhre.info/helpdesk. The link is provided in the slide, and many of you are already familiar using the help desks. When asked to select which program or system, please select Emergency Solutions Grants and an appropriate subtopic, because that will ensure that your questions get answered quickly. So without further ado, I will now hand the presentation over to Mike Roanhouse.
Good afternoon. Webinar participants will be able to describe the deadlines for obligation and expenditure of ESG funds, describe ESG program match requirements, identify 9 general program requirements, describe ESG record-keeping and reporting requirements, and locate additional ESG-related information and tools on the HRE. This webinar will not cover basic requirements for ESG grant administration, provide an overview of general program requirements, award and use of funds, and grant administration. I'm sorry, it will do that. It will not provide all the detail you will need to address administrative costs. You need to see the ESG program components and activities webinar. We will also not cover applying for the 2011 second allocation. We know that all of you are awaiting that. We've spent an enormous amount of time during the Christmas season finishing that up. We're in our final clearance with our lawyers, and we expect that to be out very, very soon, and we will have training as soon as we can for that. I know all of you are waiting for that, and we're trying to deliver that product as soon as we can with training. Now, over to Margaret.
Good afternoon. Hi. So what can we talk about? Let's begin with a review of the way HUD will award ESG funds. Next slide. As you may recall from the ESG Components and Eligible Activities webinar, which was originally broadcast on December 15th, ESG funding is allocated and awarded by HUD to states, urban counties, metropolitan cities, and territories. These are collectively known as recipients. In turn, recipients may award all or a part of these funds to subrecipients, that is, jurisdictions located within the boundaries of the recipient jurisdiction and or nonprofits serving residents of the recipient jurisdiction or some portion of that jurisdiction. The majority of subrecipients can carry out all of the activities within the components. The only exception to this is states. States may not subgrant to themselves or retain funds except in 2 instances. For administration costs, and when they do, they must share these with units of general purpose local government. And secondly, HMIS costs, where they are also the HMIS lead. So look at this chart for further clarification. Next slide. This slide summarizes how the recipient or subrecipient receives funds, the formal mechanism that must be in place for the recipient or subrecipient to receive funds, and the eligible organizations for the recipients and subrecipients. So you could use this as a good reference tool. Next slide. So once the recipient or subrecipient is awarded the funds must be obligated. State recipients have 60 days to obligate to subrecipients. If the state subgrants to a general purpose local government, that subrecipient then has an additional 120 days to obligate the funds. Metropolitan cities, urban counties, and territories have 180 days to obligate funds to subrecipients. If subrecipients wish to further subgrant ESG funds, there is not an obligation deadline. On the next slide, we will review how recipients or subrecipients satisfy this obligation requirement. Next slide. This slide references how an ESG recipient might satisfy that obligation requirement. Please note, there are differences between state recipients and non-state recipients. The regulations provide greater detail on these differences. A state subrecipient that is a general purpose local government satisfies the obligation requirement by subgrant agreement with a private, not-for-profit organization, or a procurement contract, or written designation of a department within their local government that's going to carry out the activity. Bottom line, there needs to be a written document evidencing the obligation of funds. The regulations will provide more detail. Next slide. So, once the funds have been obligated, there are certain expenditure deadlines that ESG recipients must meet. All grant funds must be expended within 24 months of the date that HUD signs the grant agreement. So let me repeat that. All grant funds must be expended within 24 months of the date that HUD signs the grant agreement. To assist recipients in meeting this 2-year expenditure deadline, the regulation includes drawdown and reimbursement requirements. Recipients must draw down funds from their annual allocation at least once a quarter during the program year. And probably more important for you subrecipients, the recipients must reimburse subrecipients within 30 days of receipt of a complete payment request. Next slide. So, we've talked about the award of funds and the deadlines for obligating and expending funds. Let's now talk about the requirements for matching ESG funds. Next slide. The match requirements for ESG vary depending on the type of recipient or subrecipient. The general requirement is that a recipient must match ESG funds with a dollar-for-dollar cash or in-kind contribution. However, there are some exemptions and some exceptions. This table illustrates those differences. State recipients are exempt from the match obligation for the first $100,000 of their annual allocation. The benefit of this exemption, however, must be transferred to those subrecipients who are least capable of providing the recipient with a matching contribution. In other words, a subrecipient for whom it would be a challenge to contribute to the match obligation may not be required to do so. Non-state recipients do not have this exemption, so they have a match obligation for the entire annual allocation. Territory recipients do not have a match requirement. Next slide. So, if you are required to match the ESG funds, what can you count as match? Match may be cash or non-cash. Match may come from federal, state, local, or private sources, but there are some restrictions. You cannot use other ESG funds, meaning you cannot use other fiscal year ESG grants to match the current ESG grant. Cannot use other federal funds if that other federal program places restrictions on their use as match. And if ESG funds are used as match for another federal program, then that federal program cannot be used as match for ESG. The regulations offer much more detail on how to calculate match and how to keep records on match. Regardless of the source of the match contribution, the use of that contribution must be on ESG eligible activities and in compliance with ESG program rules. Match may only be counted as match one time. For example, the cost of a donated building may only count toward the match obligation for one grant, that is fiscal year 2010, and not for 2 grant years, 2010 and fiscal year 2011. Okay, now I would like to turn the presentation over to Janet for the next section.
Thanks, Margaret. I did want to just mention that we are up to nearly 1,000 folks on the line, and we do know from experience that that sometimes means that there's a lag in how quickly you will see the slides on your screen. If you're having any difficulty with that, go ahead and download the presentation via the link that was sent on the chat to you, and you'll be able to look at the slides on your computer and follow along that way. All right, so I'm going to cover general program requirements. Next slide, please. On slide 18, you will see that we have 9 general program requirement topics. What we'll be giving you in this webinar is an overview of those 9 areas. And keep in mind that this is exactly what that is, an overview. You're going to need to take a look at the detailed and specific requirements in the regulation to make sure that you understand all of the detailed requirements. But this will give you the introduction you need. You can find the general program requirements in subpart E of the ESG rule. And this slide has the specific section numbers listed just so you can easily find what you're looking for. We'll be working our way through this list of topics as we go through the next couple of slides. Next slide, please. Let's begin with the new requirement for coordinating ESG-funded activities with other area-wide systems. The basic requirement is that recipients and subrecipients have to coordinate at the state and local level with other stakeholders to prevent and reduce homelessness. That's really the gist of this thing, to work with other providers to provide services in a coordinated way. To do that, there are 6 things you're going to need to think about: consulting with the COC, coordinating with other targeted homeless services, coordinating with other mainstream resources, participating in a centralized or coordinated assessment system, developing written standards, and participating in HMIS. In the next set of slides, we're going to go through each of these 6 ideas and describe what's required in a general way. But as you'll see, there's a lot more to know, and you're going to need to go to the regulation to get some of these details. Next slide, please. So part of the reason we have COCs is to help make sure that services to prevent and reduce homelessness are coordinated. And COCs can only play that role effectively if everyone who's involved in serving those who are homeless or at risk of homelessness actively consults with the COC. So the very first requirement for area-wide systems coordination is for recipients to consult with the COC. Sometimes the geographic area a recipient serves may cover territories that are served by more than one COC. In that sort of situation, the recipient would actually have to consult with more than one COC. All right, so what's that consultation all about? There are 3 types of programmatic things that COCs and ESG recipients need to consult about. The first is how you allocate ESG funds. Recipient decisions about resource allocation are going to be most strategic when you establish them with good information about what other service providers are doing. Recipients can make sure that they put their ESG funds to the most vital areas if they consult first with the COC about which components and which activities they are in the best position to serve, given what other people are doing. The second topic would be how to develop performance standards, including outcome measures for projects and activities. multiple service providers work within any given COC's geographic area. So it often doesn't make sense to think about outcomes from the perspective of a single service provider, since multiple providers can be affecting the outcomes for any given participant and for the community as a whole. So since outcome measures can't really be thought about in isolation, it only makes sense that you need to coordinate with the COC, and that's the place to have that discussion. Finally, the third type of consultation involves developing funding policies and procedures for HMIS administration and operation. As a data collection system, an HMIS is going to be most effective when everyone contributing to it provides information in a consistent way. Inconsistent data submission is always going to lead to unreliable data, and clear and accurate data is essential. Somebody's not on mute. If you could please mute. Excuse me. So I was going to tell you that the inconsistent data is going to give you the unreliable data, and to get clear and accurate data, you're going to have to make sure that you work together to use your HMIS consistently. And the best way to make sure that you really have that good data is going to be to make sure that all of the providers involved fully understand HMIS policies and procedures, and that you've got systems in place to let you provide that high-quality data consistently. That's why this third point is so important. Next slide, please. So we're on slide 21. Because making sure that the consultation happens is so important, this consultation between the recipients and the COCs, recipients have to specify how they're going to ensure that the required consultation takes place. To ensure that, the recipient's annual action plan has to include a description of how the recipient is going to consult with its COC or with each of its COCs if there's more than one that they have to work with. Recipients are also expected to get input from the COC that will help with their ESG program planning. It's not just a one-way street with recipients providing input to the COC in some kind of a vacuum. The data collected at the COC level is going to come back and inform the recipient's strategic plan by identifying the needs and gaps in the homeless service delivery system. So, for example, data from the point-in-time count and from the housing inventory count can help the recipient think strategically about where to concentrate its ESG resources. Next slide, please. On slide 22, you'll see that a major goal of the HEART Act is to provide a strategic and community-wide system for preventing and ending homelessness. To support that effort, recipients and subrecipients have to coordinate ESG-funded activities with other programs targeted to serving homeless people to the maximum extent practicable. A few examples of the kinds of organization you have to coordinate with are listed here, but be aware that the regulation contains a list of 19 specific programs that recipients and subrecipients have to coordinate with. You're going to need to look closely at that list to make sure that nothing slips under the radar. Also note that coordination can take place either across the entire COC area, but it can also take place over a different geographic area if that makes more sense for the purposes of that coordination. Next slide, please. The third area for coordination is coordination with mainstream resources. To the maximum extent practicable, recipients and subrecipients have to coordinate and integrate ESG-funded activities with mainstream resources. And that means being keenly aware of the mainstream resources that people who are homeless or at risk of homelessness may be eligible for. That coordination has to happen at a system level, meaning that recipients and subrecipients have to ensure that the overall homeless system and the mainstream resources are integrated and easy to access. You might get at this with something like a single intake form or with a centralized intake system. In addition, though, you have to make sure that there's coordination at the programmatic or project level. And by that we mean that the recipient or subrecipient has to ensure that each program participant has access to the mainstream resources that he or she would benefit from. There are examples of types of mainstream resources to keep in mind listed on your slide. They'd include programs like public housing and TANF. The regulation lists 10 specific examples of mainstream programs that ESG recipients and subrecipients may want to coordinate with. But recipients and subrecipients are also encouraged to coordinate with any other programs that might be appropriate in their area. Next slide, please. So slide 24, for those of you who are following on hard copy. The fourth area-wide coordination topic involves centralized or coordinated assessment systems. HUD is going to be requiring ESG recipients to participate in a centralized or coordinated assessment system. But note that this won't be required immediately. It won't take place until the COC regulation is published for effect and the recipient COC actually establishes a centralized or coordinated system to participate in. Recipients and recipients can begin working with their COCs now, though, to understand and contribute ideas about what that system is going to look like. Let me give you a couple of ideas about what a centralized or coordinated system might involve. HUD has some experience with this through the Rapid Rehousing for Families demonstration program. Based on what they learned from that program, HUD's developed some ideas about the kinds of systems that are going to meet the centralized or coordinated assessment minimum requirements. These will be presented in the COC rule, but here are a couple of the possibilities. There might be central locations where potential participants need to present in order to get services. There might be a hotline system to screen and connect callers to appropriate services. You might take a no wrong door approach so that referrals are consistently completed across the COC. You might have a specialized team of caseworkers to provide assessment services across the COC. Or in larger geographic areas, you might take a hub approach to serve smaller geographic areas. Once that system is established, recipients and subrecipients will be required to use the COC's centralized or coordinated assessment system to evaluate eligibility. But I do want to highlight one exception to that requirement. Victim service providers that receive ESG funds can opt not to use the centralized system. And finally, ESG recipients will need to ensure consistency between the COC's system and its own written standards for determining ESG assistance. And we're going to discuss that on the next slide. If we can go to slide 25, please. The fifth area-wide coordination topic, as I just mentioned, is written standards. For recipients that are metropolitan cities, urban counties, or territories, the requirement is pretty straightforward. They have to establish and consistently apply written standards for providing ESG assistance, and they have to describe those standards in the consolidated plan. For state recipients, it's a little more involved. States can either establish and consistently apply their own written standards, or they can require that their subrecipients establish and consistently apply standards. If states have recipients develop their own standards, they have some other choices. They can allow each subrecipient to establish and consistently apply their own written standards within their individual program, or alternatively, the state can require all subrecipients serving a given geographic area to establish and follow the same written standards. So they can let them develop their own or require some consistency. If the state wants to allow the subrecipients to establish their own written requirements, the state can do that, but the state does have to describe the requirements it will be imposing on the subrecipients in the consolidated plan. So states can require subrecipients to follow all the same written standards, but they can also give subrecipients flexibility and let them develop their own written standards. Next slide, please. Slide 26 gives you a general list of the topics that a program's written standards are going to need to cover. As you can see, there is a wide range of topics here. It's really a good starting place to give you a sense of the variety of topics you'll need to be thinking about. But those of you who are charged with developing written standards, you're going to want to consult the regulation carefully to really understand all of the detailed requirements for the written standards. Next slide, please. On slide 27, you'll see the sixth area of area-wide coordination, and that is HMIS participation. In general, recipients and subrecipients have to collect and enter data into the applicable community-wide HMIS or a comparable database. And they need to do that for all persons served and for all ESG-funded activities. Note, though, that victim service providers are not permitted to use an HMIS, and legal services providers may choose not to use an HMIS. So victim services providers are prohibited from using it. Legal services providers can choose to use it or not. In any case, a provider that does not use an HMIS is required to use a comparable database that meets the HMIS data standards. Each HMIS database has to be consistent with HUD data and technical standards. For now, HMISs should continue to follow the standards they've been following, the 2004 technical standards and the 2010 data standards. There is a new HMIS proposed rule that was published in the Federal Register on December 9th. And that proposed rule lays out ideas for altering these standards. But for now, the proposed HMIS rule doesn't change any of the current requirements. The existing standards are going to remain in place until a new HMIS regulation is published for effect. For those of you who are interested in offering ideas about what that should look like, comments on the proposed rule are due on February 7th, and you might want to take advantage of that opportunity to have some input. All right, so I want to turn things over to Tony for the first poll to make sure that you are staying with us.
Okay, everybody should see the first question, which is, ESG recipients are required to consult with local COCs about the allocation of ESG funds. And you should use your mouse or click on either true or false. And then Mike Rowenhouse will discuss the results. I'm sorry, Mike, are you on mute?
I'm here. Go ahead.
Okay, 93% of you said true, and 7% said false.
Okay. The answer is true. Recipients are required to consult with local continuums about the allocation of ESG funds, the performance measures for ESG-funded projects, and the funding and operation of the HMIS. COCs must ensure that their projects are consistent with the consolidated plan. This requirement creates a two-way communication between the COC and ESG recipients and also helps communities ensure that housing services to prevent and reduce homelessness are coordinated. Back to you, Tony.
Thank you. Okay, so your second question is, state recipients must require all of their subrecipients to comply with the same standards for determining ESG assistance. So please select either true or false.
Tony?
Okay, and state recipients must require all of their subrecipients to comply with the same standards for determining ESG assistance. We have 39% that said true and 61% that said false. And the correct answer is false. Mike?
States may establish their own standards and require that subrecipients follow them. Or states may allow subrecipients to establish and apply their own standards for implementing ESG assistance. However, if states allow subrecipients to develop their own standards, then the recipient must include the parameters of these standards in their consolidated plan. Now I think we should go on to Margaret. in evaluation of participant eligibility and needs.
Right. Thank you. So let's see. We are now on slide 29. And we have just finished talking about the first general of the 9 general program requirements, area-wide systems coordination. The second of the 9 general program requirements that we will discuss today concerns evaluation of participant eligibility and needs. The regulations address 5 topic areas when considering the general program requirements for determining eligibility and the assistance needs of ESG program participants. You'll see those 5 topics here. They are initial evaluations of all individuals or families who are seeking assistance, reevaluations of individuals or families who are receiving homelessness prevention or rapid rehousing assistance, third, determination of annual income, fourth, connecting program participants to mainstream and other resources, and then finally, housing stability case management. We will not discuss these topics in detail today, but provide, however, an overview of them. Earlier webinars have discussed in greater detail determining and documenting program participant eligibility and the various program components and activities. Next slide. This is the first topic, initial evaluations. The recipient or its subrecipient must conduct an initial evaluation of each individual or family that is seeking ESG assistance to determine program eligibility, as well as the amount and types of assistance that may be necessary for that household to regain stability in permanent housing. This evaluation must be conducted in compliance with any written standards for assistance that the recipient or subrecipient has established, and in compliance with the COC's centralized or coordinated assessment system. However, as Janet just discussed, that until the COC actually develops a centralized or coordinated assessment system and HUD publishes the COC final rule for effect, any ESG recipient or subrecipient is not required to use such a system. Next slide. So on slide 31, we were talking about reevaluations. So in addition to the initial evaluations for all program participants, ongoing evaluations must be conducted for those program participants who are receiving assistance under 2 of the ESG components. Those 2 are homelessness prevention or rapid rehousing. These reevaluations are required to determine that the household is still eligible for program assistance and that the amount and the types of assistance are still needed for that household to retain their stability in permanent housing. The timing of these reevaluations for households is not less than once every 3 months for the homeless prevention assistance and not less than once a year for rapid rehousing assistance. However, the recipient or subrecipient may require a program participant to notify them when income changes or other circumstances occur that affect the income of the family, such as the birth of a child. Then they do not have to wait for the 3-month or the 1-year mark to conduct a reevaluation. Calculating income was discussed in an earlier ESG webinar and will only be briefly discussed in this presentation. If that notification is required, then upon notification, the recipient or subrecipient must reevaluate the program participant's eligibility and the amount and types of assistance the program participant needs. Next slide. At a minimum, each reevaluation must establish that the program participant has an annual income equal to or less than 30% of area median income as established by HUD, and that the program participant lacks sufficient resources and support networks to retain the housing without ESG assistance. Next slide. The third topic area in determining participant eligibility and need for assistance is annual income. Calculating income is required for both the initial evaluation of eligibility for homelessness prevention and then for the reevaluation for homelessness prevention and rapid rehousing. This slide provides basic information about calculating income. For more information, see the resources that are listed here. Next slide. And we're now on slide 34. The fourth topic area in determining participant eligibility and need for assistance is connecting those program participants to mainstream and other resources. Recipients and subrecipients must offer assistance to each program participant as needed to obtain mainstream and other resources available within the COC or the geographic area. Examples of those mainstream resources might include Medicaid, Supplemental Nutrition Assistance Program, SSI, SSDI, unemployment insurance, and others. Not only should the recipient and subrecipient coordinate mainstream and other resources within their own program, however, they should also be working to coordinate the same resources at the system level within the COC. And Janet talked about this earlier when she discussed the area-wide systems coordination. Next slide. We should be now on slide 35. The fifth and final topic area for determining participant eligibility and need for assistance is housing stability case management. Program participants who are receiving homelessness prevention or rapid rehousing assistance must meet with a case manager at least once a month. The recipient and subrecipients must develop individualized plans to assist program participants to retain permanent housing after the ESG assistance ends. The goal of these case management sessions and of these plans is to achieve long-term housing stability and to prevent a return to homelessness. The recipient or subrecipient may, however, be exempt from this requirement of case management if they are prohibited from making housing conditional upon a participant's acceptance of services because they are also receiving funds under the Violence Against Women Act or the Family Violence Prevention Act. I'm now going to turn things over to Tony for our next set of poll questions.
Okay. Our next poll question is, program participants receiving rapid rehousing assistance must be reevaluated how often? So select one from the following: once every 3 months, once annually, or every time their income changes. Okay, I think we have our results. 35% of you said once every 3 months, 54% said once annually, and 11% said every time their income changes. And the correct answer is B, once annually.
This is different from those of you who are used to administering the HPRP assistance. Program participants receiving rapid rehousing are only required to be reevaluated once annually. The recipient or subrecipient may require program participants to notify them when income or other household characteristics that affect income change. The recipient or subrecipient must reevaluate a program participant every time an income change is reported. But having participants report changes is not a regulatory requirement. Program participants receiving homeless prevention assistance must be reevaluated not less than once every 3 months. Tony?
Okay, so our next question is, program participants must have an income at or below blank percent to continue to be eligible for homelessness prevention assistance. So please select either 30%, 50%, or 80%. Okay, so the tally is in. 89% of you, good job, selected 30%. 8% of you selected 50%, and 83% selected 80%, and the correct answer is 30%.
Program participants must have an income at or below 30% to continue to be eligible for homeless prevention assistance. Margaret, over to you.
Good responses there. All right, we're on slide number 37, and we are now going to be talking about the third of the 9 general program requirements, terminating assistance. If a program participant violates program rules, you may terminate assistance under any of the ESG components. You're not required to continue serving them. However, any termination of assistance must comply with an established formal process that recognizes the rights of the individuals affected and allows the termination only in the most severe cases. Additional standards apply when you're terminating assistance to persons receiving rental assistance or housing relocation and stabilization services under homelessness prevention or rapid rehousing. Details regarding these standards can be found in the regulation, and we will discuss them on the next slide. Next slide. If you plan to terminate rental assistance or housing relocation and stabilization services, the minimum process requirements are enhanced to reflect the longer duration and the higher expectations that are involved in homelessness prevention and rapid rehousing assistance as compared to street outreach or emergency shelter activities. This minimum required formal process to terminate includes the following: a written notice to the program participant with a clear statement of the reasons for the termination. The process must also include a review of the decision to terminate. And finally, it must include prompt written notice to the program participant of the final decision. Next slide. Program participants that have been terminated from a program may, however, receive services in the future under ESG and through that project at a later time. Next slide, please. So on slide 40, we will address the fourth of the 9 general program requirements. We will talk about shelter and housing standards. The revised habitability standards incorporate lead-based paint remediation and disclosure requirements. These apply to all shelters and to all permanent housing occupied by ESG program participants. The regulations provide for minimum safety, sanitation, and privacy standards and allow recipients and or subrecipients to establish more stringent standards. So there are minimum standards, and you also can improve upon those minimum standards with more stringent standards. Emergency shelters that are converted, rehabilitated, or renovated must also meet any applicable state and local safety and sanitation codes. Next slide. This slide gives examples of the minimum shelter and housing standards that are listed in the regs, but you also want to follow up the regs or read the regs to find more information on these minimum standards. Next slide. Slide 42. The fifth general program requirement is conflicts of interest. We're counting down, only 5 more to go. Conflicts of interest include regulatory provisions for 2 types of conflicts: organizational conflict and individual conflict. We'll start with some of the details of organizational conflicts that are addressed in the regulation. Organizational conflict relates to organizations that are carrying out the ESG program, both recipients and subrecipients. They should avoid any conflict of interest in carrying out activities funded by federal grants dollars, such as ESG. The recipient or subrecipient must not condition the ESG assistance on the participant's acceptance of housing or shelter that the recipient, subrecipient, or parent or subsidiary of the subrecipient owns. That would be a conflict. If a potential program participant lives in housing owned by the subrecipient or parent or subsidiary of the subrecipient may not conduct the initial evaluation of participant eligibility or provide homelessness prevention assistance under the ESG program to that participant. All contractors of the recipient or subrecipient shall follow the rules required of subrecipients. Next slide. The second type of conflict of interest addressed in the regulations concerns individuals. The ESG regulation incorporates language from the CDBG program regulation. For procurement of goods and services, the recipient and its subrecipients must comply with the codes of conduct and conflict of interest requirements under 24 CFR 8536 for governments and 24 CFR 8442 for private nonprofit organizations. For all other transactions and activities, the guidelines in the regs restrict financial interest and benefits to certain persons with certain types of positions for the length of their employment and 1 year after. On a case-by-case basis, however, HUD may grant exceptions to persons who take certain steps and meet certain conditions. The regs provide greater detail on these special exceptions. Now, back to Janet for more on the general program requirements.
Great, thanks, Margaret. All right, so we're up to our 6th of 9 general program requirements. This one is about homeless participation. It involves ensuring that the ESG program actively involves people who are homeless or who have formerly been homeless. The recipient's planning and policy-making process is one important area for involving people. Having homeless participation in the planning and policy-making process can really help ensure that the realities of homelessness from the perspective of those who've experienced it directly are being fully considered. In general, the way to accomplish this is that recipients, other than state recipients, are expected to involve homeless or formerly homeless people on the board of directors or whatever policy or decision-making body they have. That said, HUD has also recognized in the regulation that in some situations that may not be possible. So non-state recipients that can't meet the requirement do have the option of developing and implementing an alternate plan. That plan would have to demonstrate how they'll get input from people who are homeless or formerly homeless to help inform their policies about ESG assistance. So, for example, a recipient could satisfy the requirement by requiring each subrecipient to include a homeless or formerly homeless person on their board of directors. State recipients, unlike non-state recipients, state recipients do not have the same obligation to ensure the homeless participation, the same as the other recipients do. Under the Emergency Shelter Grants Program, the old program, there was a similar requirement to get homeless participation. And there was a process for getting input in other ways when participation on the board wasn't practical. But that whole process required recipients to submit a waiver. That waiver process is no longer required. Instead, recipients that can't arrange for homeless participation on their policymaking bodies have to include their alternate plan in the annual action plan portion of the consolidated plan. That action plan is then approved when HUD approves the consolidated plan. Next slide, please. That'll put us on slide 45. So in addition to getting policy-related input from homeless people or formerly homeless people, recipients and subrecipients also have to involve people who are currently homeless in certain activities that are funded under ESG. The areas for involvement include ESG facilities work, so things like renovating, constructing, maintaining, or operating an ESG facility, providing services assisted under ESG, and providing services for occupants of facilities that are assisted under ESG. Let me give you an example of that third one. Suppose you've got an emergency shelter funded under ESG, and there's a separately funded soup kitchen that feeds individuals who are housed in that shelter. Homeless people can be involved in serving the food under the non-ESG funded program, and that involvement would count as homeless participation because they're providing services to the occupants of that ESG shelter. Do note that homeless participation can be voluntary or it can involve employment. And also note that all this involvement we've been talking about must be done to the maximum extent practicable. Next slide, and we'll be on slide 46. The seventh general program requirement involves faith-based activities. This part of the regulation contains a mixture of protections for faith-based organizations that want to participate in ESG and requirements about how these faith-based organizations have to conduct their ESG activities to ensure that religious activities are kept separate from administration of the ESG program. So faith-based organizations are protected first in a variety of ways. Those include making them eligible to receive ESG funds on the same basis as other organizations, making sure that they retain their independence in terms of things like carrying out their religious mission, governing their own internal processes, selecting board members with a religious basis, keeping religious titles and religious references in their organizational titles, and keeping those kinds of concepts in their mission documents. They're also not required to remove religious art or symbols in order to use physical space to provide ESG services. On the other hand, faith-based organizations are prohibited from bringing their religious beliefs into the delivery of their ESG services. So faith-based recipients can't engage in inherently religious activities like worship or religious education or proselytization as part of their ESG activities. They also can't discriminate against participants or potential participants based on religious or religious beliefs. And they can't use ESG funds to rehabilitate structures used for inherently religious activities like chapels or sanctuaries. For rehabilitation of structures used for both religious and ESG-funded activities, ESG funding is limited to a percentage that's commensurate with the amount of ESG activity that takes place in the structure. And federal requirements for disposition of real property are also going to apply. Next slide, please. If a local government contributes its own funds to a faith-based organization to supplement federal ESG funds, the recipient or subrecipient has the option of either segregating or commingling those funds. If the local government funds are commingled, though, the requirements governing the use of ESG funds by the faith-based organization would apply to those local government funds as well. Next slide. We'll be on slide 48, looking at other federal requirements. This is our 8th general program requirement, so hang in there. We're getting close. There are only 9 of these program requirements. Recipients and subrecipients have to comply with a number of other federal requirements, and we'll provide a list of those requirements on the next slide. But first, let's take just a minute to think about 3 big categories. First, there's 24 CFR Part 5. That covers fair housing, equal access to housing and services, and non-discrimination. That covers race, color, religion, sex, familial status, national origin, age, handicap, and disability. All of those fair housing, equal access, and non-discrimination topics. It also covers non-discrimination and affirmative action in employment and in contracting. So you've got a wide range of non-discrimination requirements. Second, Section 3 of the Housing and Urban Development Act of 1968. This requires that recipients of certain HUD financial assistance, to the greatest extent possible, provide job training, employment, and contract opportunities for low and very low-income residents. For the purposes of ESG, the homeless individual has priority over others who might otherwise have been targeted under Section 3. So there is a provision for priority to homeless individuals. Finally, there are new environmental requirements under 24 CFR Part 50. Under ESG, the regulation governing environmental review has been changed from the regulations that were in place for the old Emergency Shelter Grant Program. Under emergency shelter grants, recipients and subrecipients were required to assume HUD environmental review responsibilities. Under ESG, that's been changed. While ESG recipients are required to cooperate with HUD's environmental review activities, recipients and subrecipients will not have the responsibility for environmental review. Next slide, please. So we're on slide 49. This slide provides a list of other federal requirements that are going to apply to the ESG program. You'll see that there is quite a long list with a dozen or so relevant requirements. I'm not going to read you the list, but know that it's here so you can find it for easy reference as you're making sure your program is going to comply with all of the other federal requirements. Let me highlight for you one important thing that you do not see here, and that is the Davis-Bacon Act. Davis-Bacon requires payment of prevailing wage rates for many projects involving federal funding, and the Davis-Bacon Act does not apply to ESG. We want to just note that meeting these requirements doesn't have to be super difficult, but if you are a recipient or a subrecipient, you will want to make sure that you really have clear policies and procedures in place just to make sure that you consistently comply with all of those requirements. Next slide, please. This is slide 50, talking about displacement, relocation, and acquisition. And this is the last of our 9 general program requirements. Recipients and subrecipients have to take reasonable steps to minimize displacement as a result of ESG-funded projects. If displacement does have to occur, then the Uniform Relocation Act, or URA, would apply. But it turns out that displacement is extremely rare under ESG. In case it ever does occur, specific requirements are included in the regulation to cover it. But we're not going to go over the details here because it's a pretty unusual situation. But do know that the requirements are in there just in case you ever need them. Let me also note that temporary relocation is not permitted under ESG. One important point to keep in mind, as we've talked about in prior webinars, is that if someone actually does receive URA assistance, that does not make them become considered a program participant. And relocation and other URA assistance is not considered rental assistance or housing and relocation and stabilization services under ESG. So receiving URA assistance doesn't make someone an ESG participant. Let's go to slide 51. All right, so we're through with the 9 general program requirements. I have just one more short topic for you before we're going to be able to wrap things up, but it's a very important one, record keeping and reporting. Next slide, slide 52, please. Recipients are responsible for making sure that all of the record keeping and reporting requirements that go with ESG are met. And to accomplish that, you're going to need to develop and implement written policies and procedures so that you make sure that you know how you're going to comply with record keeping and reporting requirements, and in that process, how you're going to protect confidentiality. For recipients, that includes ensuring that subrecipients comply with all those written policies and procedures to help ensure quality record keeping and reporting. So you have to make sure that you're in contact with those subrecipients and that all of these requirements and the way that you comply with them is trickling down. Recipients have to provide reasonable access to the records on their use of ESG funds, but that access is always subject to confidentiality laws. So you need to keep in mind always protecting confidentiality of any records you keep. Finally, recipients are required to collect and report data that's required by HUD, plain and simple. And that's going to include collecting and reporting the data for IDIS and complying with all of the reporting requirements in the Federal Funding Accountability and Transparency Act of 2006, the FATA acronym you see there, and everything that you find in 24 CFR Parts 85 and 91. We're not going to go through all of those details, but you will have to follow all of those requirements. Slide 53, please. This slide summarizes the requirements for records retention. In general, records have to be kept for at least 5 years. There are more specific requirements for records about program participants and records related to building renovation or conversion, and you see those in the chart here. Program participant records have to be kept for 5 years, but it's not 5 years from when the individual was served. The clock starts ticking only after the year in which all the funds from the grant under which the participant was served are expended. So that could very well be much more than 5 years for somebody who served early in a funding cycle. For renovation, records have to be kept for 10 years from initial obligation if the work reaches a certain scale. For emergency shelter renovation, the 10-year requirement triggers if the costs are more than 75% of the pre-renovation value. And for emergency shelter conversion, the 10-year requirement triggers if the costs are greater than 75% of post-conversion value. All right. I think there's time for us to answer one question that came up several times in the written questions that have been submitted to our resource advisors, and that is the question about whether program participants have to have an income below 30%. To receive homelessness prevention assistance initially, program participants have to have an income below 30% of area median income. To continue to receive homelessness prevention assistance, they have to be reassessed at least once every 3 months. When the program participant is reassessed, he or she or the family has to have an adjusted median income that is at or below 30% of AMI. So there are 2 separate standards, one for initial eligibility and one for continued eligibility. The difference is small. One is below 30%, one is at or below 30%, but there is a nuanced difference, and so you'll want to be alert to that. Okay, so with that, let me turn things over to Tony to see if there are other questions or if we're ready to wrap things up.
Okay, Janet, thank you. There are some resources that are currently on the HRE regarding this program, such as the regulation itself. And next slide, please. there will be some user guides that are being developed by HUD and also will be published on the HRE. There is a list, a partial list of anticipated guides that will be coming out covering items such as street outreach, emergency shelter, administrative activities, IDIS, determining at-risk status, income, etc. And when these are available, they will be on the HRE, probably under the ESG topic, and we will undoubtedly highlight these on the HRE homepage. Next slide, please. Eventually, on the HRE, there will be additional resources, including these user guides, the McKinney-Vento Act, as amended by the HART Act, all published program regulations, all webinar recordings, at-a-glance charts and sample forms, and a link directly to the ESG help desk. Next slide, please. You should now be able to, as a result of listening to this webinar, understand or describe the deadlines for obligating funds and expending them, describe the ESG program match requirements, at least identify the 9 general program requirements that we discussed, and describe ESG record keeping and reporting requirements. And then hopefully you will be able to locate the additional ESG related information and tools on the HRE. So I'd like to take this opportunity to thank our panelists very much for their presentation, and also to our resource advisors for fielding questions. And also thank you to all of you for taking time to participate in this webcast. As a reminder, if you have additional questions, please submit them through the virtual help desk. Also, this webinar recording and PowerPoint presentation will be posted on the HUD HRE website. And as you know, the slides are already available. After the webinar, through Citrix, you will receive a link to SurveyMonkey. And we ask that you complete the brief survey to let us know how we're doing, because we're very interested in obtaining your feedback on these webinars. Please join us next Tuesday for the webinar on substantial amendment process for second allocation of fiscal year 2011 ESG funds. And thank you again, and enjoy the rest of your day.